Welcome to Planet Lex, the podcast of Northwestern Pritzker School of Law, with your host, Dean Daniel B. Rodriguez, bringing it to you from Chicago, Illinois. Take it away, Dan.
Hello, and welcome to Northwestern Law's Planet Lex, podcasting from the Northwestern Pritzker School of Law in Chicago, Illinois. My name is Dan Rodriguez, your host. Today I have the pleasure of being joined by not one, not two, but three of my able Northwestern Law faculty colleagues to discuss recent decisions and actions by President Trump and the legal considerations facing this new administration. I should mention that we are recording this on February 7th. Obviously, news has been breaking pretty quickly in this administration. So while we're not fixed in amber, as it were, our listeners will know that we're talking about this in the early part of February into the new year. So my guests, Andy Koppelman, the John Paul Stevens Professor of Law, who focuses on issues at the intersection of law and political philosophy, constitutional law, and many other cognate subjects. His most recent books are The Tough Luck Constitution and The Assault on Healthcare Reform and Defending American Religious Neutrality. Professor Eugene Kontorovich, colleague at Northwestern, who specializes in constitutional law, federal courts, and public international law. Eugene has published over 30 major scholarly articles and book chapters in leading law reviews and peer-reviewed journals in the United States and Europe. Professor Deborah Tuerkheimer, who has joined me before as a guest, as listeners will know, is a criminal law, evidence, and feminist legal theorist here at Northwestern. She's a former assistant district attorney and a frequent contributor to Slate. Her most recent book is Flawed Convictions, Shaken Baby Syndrome and the Inertia of Injustice. Thank you to all three of you for joining me here this morning. So let me just throw this out here and ask you to, there's so much to cover, even as we speak here in early February. So let me begin with lawyers and the courts, and I'll start with lawyers. Talk, if you will, any one of you or all three of you, about how, if at all, the role of lawyers will be different under this new administration.
So this is Andy Koppelman. I think that one of the interesting continuities between the Obama administration and the Trump administration is that there are, in each case, well-organized groups of lawyers who are hostile to what the administration is trying to do and are able to use the courts in quite skilled ways to try to prevent the president from accomplishing what the president wants to accomplish. And while that might not be part of the originally contemplated system of checks and balances, it's certainly something that any president, I think, is likely to have to deal with hereafter.
Can I jump in with a follow-up? Is President Trump at a disadvantage by not being a lawyer, or does that not matter, given obviously the legal advice he has from the White House counsel's office, Department of Justice, et cetera?
Well, he can remedy that deficit. Any president can remedy that deficit by running his proposals past the White House counsel and the Office of Legal Counsel before he promulgates it. That's something that I think that President Trump is learning.
Yeah, I would just add to that, to the extent President Trump evinces respect for the rule of law, for the Constitution, I think lacking a law degree is not a disadvantage. The concern is that he hasn't yet shown that kind of respect for rule of law, for constitutional norms. That's where the lawyers, I think, do play a really important role. Talking, to many of our students here at Northwestern who are feeling activated, who are feeling mobilized, who are feeling like this is a particularly important time for people who do believe in the importance of law, separation of powers, constitutional constraints, for lawyers to be very involved, to be very active, and to be those checks and balances that Andy mentioned earlier.
You said hadn't yet, so I might, if I may say, that comes at it with a somewhat light touch. Others would say that and others have said, that he has evinced hostility beyond the pale with respect to the judiciary. And again, as we record, the United States Court of Appeals is about to hear an appeal from a judge's decision in Seattle. And within hours after that decision, President Trump, tweeted an infamous line that called the judge a so-called judge. And a number of individuals within law schools and outside of law schools leapt onto that and said that reveals this pattern on the administration, the president in particular, of not only disregarding but speaking very pejoratively about a co-equal branch of government.
So one should remember, Donald Trump's tweets, of course, are a thing entirely new to the world of politics, both in their wide-rangingness and their extraordinary tone. But in terms of criticism of the Supreme Court, and even sharp criticism, We heard some of that from President Obama, even in particular before the decision of the court in the Affordable Care Act case, the Sebelius case. The president strongly addressed the court directly and said that it could have bad consequences for the court and its legitimacy if they failed to do the right thing, which, depending on how seriously you take each president, could be a greater or lesser form of intimidation with this judge and Trump's tweets. Indeed, I think it proved to be more effective than Trump's tweets will prove with respect to this judge. The courts were severely criticized by Attorney General Holder after Citizens United, where they were called lawless and totally misconstruing the Constitution. So that kind of criticism is not new. Now, obviously, President Obama, Attorney General Holder put those criticisms in a different manner than an inflammatory tweet. But it's not clear to me that the general content was quite different.
So I think that one distinction, certainly a distinction that a lawyer would keep in mind advising a client, is that it's one thing to express disagreement with the reasoning of a court, and it's a different thing to personally abuse the judge. That, any lawyer will tell their client, do not make statements in the press personally abusing a judge, because among other things, it is going to dispose the judge to rule against you, and saying that, if there is an attack in the future, blame the courts. It seems to be a level of pressure on the courts, I think, certainly different in degree, possibly different in kind from what President Obama did. And if I were President Trump's lawyer, I'd tell him the concern here is that you now create a situation where if the courts rule in your favor, they will worry about being perceived to be caving into pressure. And so this will predispose them to rule against you. And so it's counterproductive, even in the instant litigation, never mind ideas about the propriety of presidential statements and the like.
Well, whether we agree or disagree about the propriety of President Trump's criticisms, I suspect we can all agree that he will have the most influence over the courts with respect to who he appoints to the courts. And of course, just in the last few days, he made his first important appointment in the form of the nomination of Neil Gorsuch to the United States Supreme Court. I wonder if each of you would say a few sentences about what you think about that appointment.
Well, in some respects, he's not as extreme as some, particularly on the left, feared the appointment might be. That said, there, I think, is great concern, and legitimately so, that future appointments will pull the court farther to the right. This is obviously a replacement for Justice Scalia, and I think in many respects, a Justice Gorsuch would do much of what Justice Scalia did on the court, particularly with regard to the Fourth Amendment, to sort of criminal justice issues, to many constitutional issues where he's written opinions. It looks a lot like a Scalia. What we don't know, and this is of particular interest to me and I know to many others, is where Justice Gorsuch will come out on the question of Roe versus Wade. This is something that Trump made very clear was important to him. It was a litmus test, as he put it. And so one might have expected that the justice would be committed to overturning the case of Roe versus Wade. It's not entirely clear that that's where Justice Gorsuch will come out. His writing has been on the related subject of euthanasia, physician-assisted suicide, and so he's made some comments that some have interpreted to be sort of anti-choice, anti-abortion, about the sanctity of life. That said, he's been very careful about drawing a line between the topic that he was discussing in his book on the subject and Roe versus Wade. And I think that it would be difficult to make firm predictions about where he will come out if and when the court is in a position to revisit that holding.
The question of overturning Roe versus Wade is, I think, a complicated question. Of being against Roe versus Wade, I think, is a complicated question with maybe several different parts. One is, would Judge Gorsuch have voted for the result in Roe versus Wade? Does he think it's a good decision and a correct decision? That itself is separable from the question of whether he would vote to overturn it, which indeed the Supreme Court has already voted in part to overturn it in Casey, though not in broad part, but certainly abandoning the trimester system of Roe versus Wade. And of course the third question, and I think it is unlikely that he would vote to overturn Roe versus Wade in a broad and blanket sense. And the third question, which is probably the most relevant, is how he would vote on particular detailed questions of various individual state regulations or restrictions in the area of abortion, which are not abortion bans, but maybe in the area most litigated now, so-called undue burdens, that is to say, around the edges rather than at the core. And that is indeed where most of the litigation is now. And I think those are three all very different questions.
So I think the reason why the conversation focuses on abortion is because of the various issues before the court. It's one of the weightiest. There's, either it is the case that large numbers of babies are being killed, or that large numbers of women face the prospect of being compelled to have children against their will. And either one of those is pretty bad if you accept the description. So I think that's why folks focus on it. I agree with Eugene that the question that's likely to come before the court is not absolute bans on abortion. If I were in the right to life movement, I think that I'd be less eager to do that than to enact the kinds of restrictions that Texas enacted that were just struck down by the court that make it much more difficult to get abortions because those are lower visibility, they're harder to reduce to a soundbite, and you can effectively ban women from having abortions in large parts of the country without saying that that's what you're doing. And so if the court wants to do that, or if a state wants to do that without mobilizing the other side, that would be the way to do it. I think more generally, the question about Gorsuch, it's really a question about the departures from normal procedure in the case of Merrick Garland, where for nearly a year, the Republicans refused to so much as hold a hearing on him. So, one aspect of the political system, and this goes to Trump's presidency generally, any political system depends not only on the written rules, but protocols for carrying on that everyone takes for granted, even when against interest, in order to smooth the operation of the system. And those have been generally degrading over time. So would the idea that, some Republican leaders came pretty close to saying that presidents just don't get to appoint Supreme Court justices in the fourth year of their term, which is a crazy rule, but that was the rule to be followed. And so there's some inclination on the part of the Democrats to punish that by saying, well, if you are going to use all of your parliamentary resources to block a nominee because he's a Democrat, and a number of them said that if Hillary Clinton had won the presidency, they would try to keep that seat open, that it isn't appropriate to have a regime in which only the Democrats follow the rules, the unwritten rules, and the Republicans don't. So the inclination on the Democrats' part is to say that 60 votes are required in order to get this through, and either you abolish the filibuster rule or the seat is going to remain empty until Trump appoints someone who is acceptable to the Democrats as well as the Republicans.
On that point, what is your prediction about how likely it is that the Republicans will utilize the so-called nuclear option in order to overcome the filibuster?
If the Democrats hold together and continue to block Gorsuch, then I think that the Republicans will certainly use the nuclear option because they want to fill that seat. And if they are in a position where their only way to fill the seat is the nuclear option, then I think that they will use it, which I actually think as a constitutional matter is appropriate. The Senate has become extremely dysfunctional because of the de facto rule that's been adopted in recent years that you need 60 votes to do anything. So I think that it's probably better for the operation of the constitutional system that 60-vote rule be degraded at every opportunity because it really is an extra constitutional rule. What I fear, and the temptation that I worry that the Democrats will succumb to, is to turn this into an issue of personal attacks on the nominee and claims that the nominee is not qualified. And that's just not the case. Gorsuch is as qualified as any Republican nominee, and it should not be about him. It would be a mistake for the Democrats to make this about him.
Well, let me ask this. If we can stipulate that Gorsuch is within the mainstream in some broad sense of mainstream conservative thought, of course, what is ominous from the vantage point of many folks who have concerns about the Trump administration is the next appointment and the next appointment after that, particularly if the appointment replaces someone in the middle, someone like Justice Kennedy, someone on the left, someone like Justice Ginsburg. So again, asking you to make a prediction, what would you imagine would be the position of the Trump administration on the next nominee? Is this an instance, as has been written about in some ways, in which he's offering up an easy mainstream nominee only to get ready to appoint somebody who might be much more radical coming up next?
I think it's very difficult to speculate about that. One, may Justice Kennedy and Justice Ginsburg live long and be well. There is no guarantee that Trump will have occasion to replace them or when he will have occasion to replace them. Right now, I understand the Democrats' strategy, but it's a weak one because they're in a weak position, just having lost an election fairly decisively, especially in Congress. In 2 years, their position may look a lot better or worse, and his ability to push things may be different. But I think on the whole, it's not surprising that a conservative or Republican president will attempt to appoint conservative and Republican people. To quote our former president, elections have consequences, and some of those are felt on the Supreme Court. And in terms of the Gorsuch nomination and the Garland nomination, I think both the Democrats and the Republicans were right. The Republicans were right in Garland, Judge Garland. I think when they stated their view that the president does not have a right or a power or is somehow limited from appointing justices in his last term, that's clearly wrong. But when stated, I think, more modestly, that he does have the power to do so and they are under no obligation to give their advice and consent, and they could be obstructive and difficult, that's clearly right. And the Democrats are clearly right that they can be obstructive and difficult retaliatorily and for a new president. The difference, of course, is the power dynamics are very different in a nomination in the last. It's not a formal difference, it's a practical difference. The power dynamics are very different in a last term than in a first year of a term. The Republicans' strategy, which seemed absolutely unlikely to succeed at the time, was to wait President Obama out and somehow do better, which seemed almost wild and insane. But indeed it succeeded. But the Democrats are very unlikely to wait Donald Trump out, especially if further seats become vacant. And the accumulation of vacancies, I think, would be unlikely to look good. And the Republicans almost certainly will invoke the nuclear option. And I think the reason that is likely is because the Democrats have already invoked it for other judicial candidates. And I think we have crossed exactly that point that Andy mentioned, where the non-legal structure, the norms, the manners, and the institutions of reciprocity have evaporated, maybe at a time when people would think it would be most useful for them to still exist. But I think it is hard to believe that they will still exist.
The norms of reciprocity, of course, we have not gotten to the absolute bottom of norms of reciprocity. So Congress flirted with the possibility of defaulting on the debt of the United States in order to win a political point. They did not go there. That does not mean that they will not go there in the future. And of course, there's a famous episode when one member of Congress beat another one unconscious with a cane on the floor. So it can get worse.
In the last century, let me just hasten to add, for the benefit of our listeners.
Before the Civil War.
Thank you, 2 centuries ago. Let me turn the conversation, if I may, away from the courts. There's so much, of course, involving the Trump administration, the role of law. And actually, let me ask this question to Deb. When last we spoke in this setting, we had a good conversation about the role of the Obama administration in Title IX and the Dear Colleagues letter. Commercial announcement for those who don't recall that conversation. It is available on Legal Talk Network. But back to the point, now a new administration and a question that looms large, which is the role of the Department of Education, the Department of Justice, with respect to this very difficult issue, particularly for colleges and universities, as you know, which is Title IX in that scope. What are your thoughts about what is to come?
I think we're going to see a sea change in the federal government's approach to this question. And I guess I'll focus on the Department of Education, in particular the Office of Civil Rights, which has been very active, which was very active during the Obama years in really aggressively pushing colleges and universities to take seriously their obligations under Title IX, which is a statute that deals with gender equity in education. And so what we saw during the Obama years was an active effort to get colleges to apply a preponderance of the evidence standard in these hearings. That is something that the Republicans in their platform made very clear they are not supportive of. Schools that were under investigation have been publicized in the Obama years. It is no longer clear that that will be the case. These investigations require funding. It is not clear that these investigations will continue to be funded. And so there are all sorts of ways in which a Trump administration, particularly a Betsy DeVos Department of Education, can really pull back on the progress that we've seen. In particular, there's this notorious now Dear Colleague letter, notorious or inspirational, depending on your perspective, a Dear Colleague letter, which did for one, put into place this notion that the appropriate standard for adjudicating claims of sexual assault on campus is preponderance of the evidence. It's not a higher standard, and this is the standard that now proliferates. So if that is challenged, the Trump administration doesn't have to defend the lawsuits that are pending. And I want to say something interesting about that. One organization that has been actively opposed to this approach, and to this Dear Colleague letter in particular, is called FIRE. It's the Foundation for Individual Rights in Education. That's an organization that has received donations from, among others, Betsy DeVos. So on top of the GOP platform, which is fairly hostile to the idea of federal intervention in this area, we have now a head of the Department of Education who we have every reason to believe is also quite hostile to these efforts. So we can talk about, whether activism and other kinds of non-governmental efforts will keep this issue at the forefront. But again, going back to where I began, I think we should expect that coming from the Trump administration, we are going to see a pulling back of efforts in this regard.
Thank you. Let me shift the focus. And what's on our minds, many things are on all of our minds, certainly the litigation over the immigration ban looming large, and welcome all of you or any of you to talk about that. But I actually would like to kind of pull the lens out a little bit further and ask you a bit about executive power and the conversations in the press and elsewhere about executive power. I couldn't resist noting that my good friend, former colleague, John Yoo, he would want to be introduced in other ways other than this, but one of the co-authors of the so-called torture memo, member of the administration in the Bush administration, written as recently as, I think, the day before yesterday, that the Trump administration portends the undue expansion of executive power, which of course generated about tens of thousands of tweets saying, if John Yoo believes that the Trump administration has gone beyond the scope of executive power, then maybe it has. So I'm looking at Eugene, maybe to weigh in on the question of what threats or opportunities are portended by the Trump administration's view on executive power.
We all stand on the shoulders of giants, and it is highly likely that Donald Trump will try to expand executive power because every president since him in recent memory has done the same. That has been the clear trend. I think when people express concern about Donald Trump expanding executive power, they mean that he will use it in ways that they do not find desirable. But President Obama was extremely assertive in his uses of executive power in terms of executive orders, granting exemptions under the Affordable Care Act, deferral of immigration, and broad executive policy making. And indeed, this offers, I think, the Trump administration offers an opportunity for liberals and conservatives, if they were to come to their senses, liberals who are horrified that Donald policy will implement the kind of policies a Republican is likely to do, and conservatives who have long-standing concerns about constitutional drift to make a grand compromise. If one's scared about Donald Trump as president doing so many things, maybe it's because the president has too much power to do things. Now, again, to rein in and to have a bipartisan consensus to rein in the powers of the executive would require, I think, the levels of trust and reciprocity expectation that probably do not exist. But it's a very good opportunity where, in a sense, the shoe is on the other foot. That is to say, liberals are concerned about Trump, and they are generally those who have favored the expansion of the administrative state and care less about federalism and limits on the power of the federal government vis-a-vis the states. And conservatives who worry a lot about these things in theory probably will not worry about it so much in practice when it's their guy. And so theoretically, and this is the idea of constitutional arrangements, is to make deals that lessen the volatility. That is the very sense that there's so much up for grabs, which is a sense the conservatives had when President Obama was elected, is perhaps a sign that something is wrong, not with the Trump presidency, but with the system in which much is put up for grabs. One notion of the role of the Constitution is to limit the scope of up-for-grabness in any particular election. In countries that have coups and violent transitions between power, it's because people feel everything is up for grabs in every election. And so beginning to seriously think about a mutual and general agreement of restoring such limits would be very valuable. And I see, for example, one example of this is a discussion that's begun involving people like Professor Heather Gerken about progressive federalism. So federalism is seen as one way of resisting the president's immigration policies through rights of states to implement or permit sanctuary policies. And I think it's a great idea because I'm a big supporter of federalism, not because of any view of the policy issues. But I must say, for this to work as a compromise that would be generally accepted, it needs a better name than progressive federalism, which makes it sound like it is federalism for one purpose only. Why not call it, interesting name, federalism? And that would be great.
I think I agree with what Eugene just said, and I think that I'd add that to the extent that there's consensus, part of it is consensus about procedures. The other thing that President Trump has challenged is consensus about substance. The one place where I think that we've seen substantive overlap between the Democratic and Republican leaders in Congress, and I think it hasn't been reported in the press as much as it should have been, is over the question whether the United States cares whether Russia invades its neighbors, which has been a central issue of American foreign policy since World War II, and a position that Trump took during the campaign and continues to be open to is that it really isn't much concern of the Americans what Russia does. And the Democrats said quite early on that if President Trump unilaterally lifts sanctions on Russia for the invasion of Ukraine, that they would introduce legislation to override that.
With strong support of the Republicans, particularly
that's the thing.
McCain and Graham. And
not just support from McCain and Graham is one thing, but it was indicated that Senator McConnell and Speaker Ryan would also be sympathetic to allowing that to go forward if Trump were to unilaterally lift sanctions. And so, this is really huge because my guess is that them saying that is sufficient to deter President Trump from unilaterally lifting sanctions with enormous geopolitical consequences.
Sufficient but maybe unnecessary, because one of the surprising things I think about President Trump, even though he has said things that I personally regard as quite shocking about Russia, interestingly, his Secretary of State, his other senior national security officials have really said the opposite. And Ambassador Nikki Haley, as ambassador to the United Nations, has denounced Russian annexation of Crimea in extremely strong and clear terms. And the breadth of opposition to these Russian policies amongst cabinet-level officials suggests, A, that it's unlikely that radical changes will occur, and B, actually, I think puts Donald Trump in a surprising kind of light that he could appoint and tolerate people who disagree with him on such marquee issues. But in the end, I think this is an area where there's not going to be much difference except in tone between the Obama and Trump administrations. So President Trump has a very conciliatory tone to Russia, and President Obama had a less conciliatory tone. But nonetheless, the invasion of Crimea, the Russian invasion of eastern Ukraine, did happen during the past 8 years of the Obama presidency, and while sanctions were imposed, they have thus proven entirely ineffectual, and various stronger measures that were discussed, kicking Russia out of the G8, kicking it out of the Mideast Peace Quartet, were not indeed implemented, and the U.S. wound up coordinating joint air operations in Syria with Russia. So the tone is very different, but I don't know if the substance is going to be that different, assuming that the cabinet-level officials play a restraining role, which I pray that they will.
That's entirely uncertain. In the event of a conflict, President Trump outranks his cabinet officials.
As every president. Let me ask, the so-called war on the press that has gotten a lot of notoriety in the press, right? Just bringing it to the legal issues. In the campaign, President Trump, then candidate Trump, talked about redoing the libel laws, perhaps that being the tip of the iceberg in terms of a reaction, legal reaction, in addition to a tweet reaction, but a legal reaction with respect to the press. Is there any room for horror, if that's your perspective, or confidence, if that's your perspective, that the Trump administration will actually make some substantial changes with respect to the laws dealing with the press?
The thing about changing the libel laws, first of all, most libel laws are state laws, and he can't really do anything about those. And I cannot see Congress supporting any kind of broad reworking towards what seems to be a British libel system, because the British libel system is the nightmare of the world, and nobody seems to want it, and everybody wishes to seek to flee from it, except for plaintiffs who wish to flee to it. But it would be an extraordinary change which would require legislation.
The other thing that I think you'd have to add about what candidate as the then was Trump said is that there are constitutional restraints on libel law, that New York Times versus Sullivan means that it's not possible to sue the press for statements about public officials unless you can show that those statements were made at least with reckless disregard of the truth. And so that would require a change in constitutional law. And right now, I count 0 votes on the Supreme Court to overrule New York Times versus Sullivan. I suspect that candidate Trump didn't know any of this. The way that he described the change in libel laws he contemplated, he seemed to think that the president had the power to rule by decree, which actually is not the American constitutional system.
So the prospect of Trump v. Saturday Night Live is unlikely in our
I think
short-term
it's
lifetime.
safe to say that.
So here's a provision of the Constitution that I think it's fair to say has been the subject of little or no litigation in our 200-plus years, and that's the so-called emoluments clause, which has gained some attention given real concerns about potential conflicts of interest on the part of President Trump and the Trump administration, particularly President Trump. Any views about what the courts would be likely to do about a claim of a violation of the emoluments clause?
I think it's very clear what a court would be likely to do about a claim of violation of the emoluments clause, and indeed such a claim has been filed by some of our colleagues at other universities. I think a court would be extremely likely to say that it presents a non-justiciable question, that is to say that the plaintiffs do not have standing to raise this, because the Constitution requires the court to adjudicate cases, which is disputes between people. In other words, something is being done to someone. But it's not clear that Trump is receiving any alleged emoluments against somebody. And there are analogous clauses of the Constitution, like the incompatibility clause about holding a legislative and executive position, the accounts clause requiring Congress to publish all of the money that they spend, which have been found to affect everybody so commonly and so generally as to be very difficult to raise a case before the court.
It may be possible to get around the standing question, that we get deep into the weeds there. But it seems to me that the litigation is trying to accomplish two things. One is it's not clear whether you'd be able to get a court decision. The emoluments clause says that you can't accept a present or emolument from any foreign state. And we don't really, because Mr. Trump's business dealings are so opaque, we don't know who his investors are. We don't know whether foreign countries are patronizing his hotels and delivering them business for the purpose of currying favor with them. This is really unprecedented, and it seems to me one of the things that the lawsuit is trying to raise is the impropriety of this whole arrangement. If I were a foreign government that was trying to secure some favor from President Trump, I would think that it would be prudent to continuously book large blocks of rooms in Trump hotels, because what do you know, it might help. And that is exactly the kind of state of affairs that the emoluments clause was meant to prohibit. And these provisions, when the Constitution was originally put in place, they didn't contemplate judicial review so much as something to which you could appeal to the people.
Well, on that point, even if there's no judicial redress to this, he did put his hand on the Bible and take an oath to defend the Constitution. Could imagine that Congress, in drawing up the House of Representatives and drawing up articles of impeachment, could consider if, in fact, their belief that this is patently unconstitutional could have redress. In other words, there'd be non-judicial redress.
There are non-judicial forms of redress, both through Congress and through the people themselves. But one thing I would never say about the violations of the emoluments clause is that they are patently unconstitutional, because, again, there are no cases, and we really don't know what an emolument is, but we do know something about the sentence it's in. It's in a sentence banning the receipt of gifts and titles of nobility. And what do those things have in common? They are gratuities. They are, pure freebies. And that does not, Congress knows how to use the word commerce and transaction. The Constitution knows how to use those words. But rather, it seems to be discussing a category of pure benefit rather than benefit for consideration for normal business dealing. I'm not saying that means the emoluments clause doesn't. I think anyone who says they know what it means needs to specify much more their basis. One might have a feeling, but I think it is very far from clear. Now, as to the unprecedented question, I think there's a great research project out there to do. George Washington did not put Mount Vernon into a blind trust when he was president, and they continued to grow various cash crops. And an interesting question would be whether any of them were for export, and whether they were exported purely to private parties, to foreign counts or princes, or whether he took any effort or had any thought that that was an important restriction.
And the question would be a violation of the emoluments clause if some foreign prince were to purchase Washington's commodities at 150% of their market value.
Deb, let me ask you a question. We haven't been focusing so much on the Trump administration, maybe with a thumb on the scale about the White House's role in all this, but the Department of Justice is going to play a very, very important role, as it does in all administrations, and Senator Sessions will be confirmed as Attorney General. Could you talk a little bit about the new role of the new Department of Justice?
It's going to look very different from the Department of Justice that we're used to. Jeff Sessions, by all appearances, is not interested in promoting civil rights, which is sort of a fundamental component of what the Department of Justice is supposed to be doing. He's sort of indicated that LGBTQ rights are not a priority for him. He's indicated that women aren't discriminated against in ways that he recognizes as actionable. We can expect that hate crimes will not be aggressively prosecuted. We can expect, again, sort of pullback on statements that the Obama administration made about the importance of trans rights and protecting trans folk. We can expect that criminal justice reform will be set back. There's bipartisan consensus, I believe, that this is sort of important and that mass incarceration is real and it's a problem we all need to confront. And yet, Jeff Sessions has been on the record sort of opposing these sorts of evolutions in the way that we do business in criminal justice. Federal charging practices, we can expect, will be far less liberal than they were under particularly Attorney General Eric Holder and his leadership with regard to not aggressively prosecuting low-level drug dealers and doing everything in his power to be certainly protecting communities, but also recognizing that we need to be scaling back on incarceration. These are issues that, again, there's some fairly widespread consensus about. Jeff Sessions is very far to sort of outside the mainstream on these issues. And I will say this as well. The Obama administration was very aggressive about using a pattern and practice statute to ensure that policing practices were constitutional, to ensure that in cities like Ferguson, in cities like Chicago, the police were not violating the constitutional rights of citizens. There, too, Jeff Sessions has put himself on the record opposing, this kind of use of this statute 14141. And we can expect to see much less in the way of kind of overseeing police departments, holding police departments accountable for what I think Black Lives Matter has particularly put in the forefront of public consciousness.
Thank you. So this is a time in our program, I've done this in the past, which I call borrowing from someone else, lightning round. So there's so many issues we're not going to get a chance to cover. But what I'd like to do is to go through a little bit of a checklist of some hot button issues, all drawn not only from the headlines, but some issues that candidate Trump was talking about on the stump, and see if we get your very short thoughts on what you think will be the fallout and what is to come. Anybody can jump in. Takings. So eminent domain, candidate Trump excoriated the Supreme Court's decision in Kelo on the campaign trail, the case that gave a broad interpretation of the public use requirement and takings clause. Any promise of the Trump administration with respect to takings?
It wouldn't be up to the Trump administration. It would be up to potential Justice Gorsuch and his successors. And there has been a lot of backlash against Kelo in both the academy and in the states, which have changed their laws to avoid replicating a Kelo-like outcome. So it's not inconceivable that the rule in Kelo, which is extremely broad in its authorization for private-to-private takings, could be limited, though I don't think it would be entirely reversed, because the prior precedents before Kelo were not maybe universally expansive, but were still very expansive.
This, too, will be an issue for the courts, but also the Department of Justice may play some role, and that's affirmative action.
I would expect that under this Justice Department, the Justice Department would be quite hostile to affirmative action, possibly to the point of bringing lawsuits against private entities that practice affirmative action. So you'd really see a complete reversal. And it's just hard to tell, with Gorsuch's vote, how the court would come out. I guess with the present court, Kennedy would continue to be the decisive vote.
Because Gorsuch replacing Justice Scalia,
yes.
whose views on.
And Kennedy is willing to entertain affirmative action if he can be persuaded that there is no alternative, which he sometimes can be.
Interesting. So here's an issue we've touched on, Eugene, when we were talking about, and Andy, about issues of international law and also executive power. President Trump's talked quite a bit about getting out from under bad treaties or bad international agreements. And so this issue that might loom large in the coming administration, which is the president's power to unilaterally abrogate treaties or withdraw from foreign entanglements of different kinds. You expect that to loom as an issue? You've heard about NAFTA and NATO paying for themselves. Those are the big blockbuster ones. But of course, as we know, there are a number of other international agreements. Would they be on the chopping block in the Trump?
So I think it's extremely unlikely that the president will try to exit NAFTA because it is almost unexitable. It is instantiated in hundreds, if not thousands, of statutes and regulations domestically. And so even if the treaty is formally terminated, which I think would be an extraordinarily drastic and consequential step, in a sense, the United States would still be obligated and limited by it in many ways. He has spoken about terminating the Paris Climate Accord, but that is not an example of the president's power to make treaties, because President Obama, not wishing to submit it to the Senate, made clear that it was not, in fact, a treaty, but merely an executive order which he signed and which could thus be changed by a subsequent president.
I think that does bring to mind another issue that we've not yet talked about, which is the Trump administration and climate change, the Trump administration and environmental regulation. These are all serious concerns for people who do worry about these issues.
One last question on this lightning round is the Trump administration's role with respect to drugs, and particularly when asked about marijuana. Been a lot of activity in the states. California, during the election, enacted a law approving recreational use of marijuana, puts now 3 states on board. But there's always been sort of looming in the background the question of what the feds would do, if anything, to come into conflict with those state initiatives. Any reason to believe the Trump administration will jump in and try to countervene those states?
Yeah, I think there's reason to believe that could happen. Again, Jeff Sessions has sort of put himself on record as being opposed to these liberal marijuana laws. Whether there's a counterbalance in other parts of the administration and they can kind of pull him back because it seems to go against the grain that you described. But for people who would look to the states to be sort of liberalizing and modernizing around marijuana, I think there's cause for concern.
Just to flip that around, could it be that the Republicans, not only the administration, but also the Republicans in Congress, embrace of federalism and states' rights in some way may redound to the benefit of those states that are acting, as Justice Brandeis famously said so many decades ago, laboratories of experimentation, in this case with respect to marijuana?
Right. I mean, in this upside-down world in which we find ourselves, it's really hard to know how these cross-currents kind of result in policy change. There's hostility to innovating when it comes to, say, California and its protection of immigrants, right? And so we can see that there are these strains within the Trump administration where President Trump seems to be inclined to sort of advance his position regardless of whether it's consistent with what, as you point out, Republicans have for quite some time been advocating.
Mm-hmm. Let me just ask this by way of wrap-up. If you peer into your crystal balls and you're looking now at this conversation 4 years from hence, maybe more nominees to the Supreme Court, maybe, and with respect to many different developments, how will we look back at this term, this 4 years, in terms of its impact on key issues of law, statutory and constitutional law?
It's very hard to tell because the range of possible outcomes of this administration are enormous. There are some respects in which President Trump is simply a normal Republican president. Certainly, as soon as Rex Tillerson was confirmed as Secretary of State, all of those normal State Department statements came out immediately after he was confirmed as Secretary of State. But we don't know whether he'll be allowed to do that. President Trump could fire him tomorrow and unilaterally lift sanctions and hope that he'll be able to keep that through Congress. We just don't know. He could, Steve Bannon has said that he thinks that, maybe we're going to have to go to war with China over those islands that it's been constructing. So how we will look back really depends on what happens. In some ways, he could be a normal president. If you got into a nuclear war with China, that would be something that it would take a while for the human race to recover from. So, just it's not possible now to say what this is going to look like.
Deb, can you bring us to a happier note?
I don't know happier, but I guess I will be a little bit more emphatic about the fact that I don't think he's a normal president by any stretch. I think that this is far outside the norm. I think that he's, extraordinary in all sorts of ways, and I don't expect that that's going to change in the course of the coming years. What I think is the unknown is the extent to which he will be checked, and his impulses will be balanced by, for instance, a Congress that's willing to sort of be involved meaningfully, by the courts, which we've talked some about, by activism on the left. And, to my mind, that's where there may be some reason for hope and for optimism is to see sort of these forces galvanized. I am not going to place stock in sort of President Trump coming to his senses and starting to behave in ways that are more respectful of the law, the Constitution, most vulnerable populations, most marginalized populations. I'm not going to wait for that. But what I do hope is that we see over the coming years some resistance, some sort of meaningful show of force so that his goals, his plans, his agenda is somewhat tempered.
Great. Well, with that, I want to wrap up. I want to thank our guests, able Northwestern faculty members, Andy Koppelman, Eugene Kontorovich, and Deb Tuerkheimer, for joining us. Thank you for listening. I'm Dan Rodriguez, signing off from the Northwestern Pritzker School of Law.
If you'd like more information about today's show, please visit law.northwestern.edu/planetlex or LegalTalkNetwork.com. Subscribe via iTunes and RSS. Find both Northwestern Pritzker School of Law and Legal Talk Network on Twitter, Facebook, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Northwestern University, Legal Talk Network, or their respective officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.